Mr. Henderson, I want you to understand, if I go along with this today and you're back in here, I'm going to see all of this and I'm going to wonder what I was thinking today. And that's not going to be good, because if you will be agreeing today to a certain amount of time in prison. And so we're not going to come in here and negotiate. You mess up again, you're going to be in here getting all the sentences that you're getting. Do you understand? Do you understand?
Yes, ma'am.
Okay. So what is the agreement is just to continue those probations?
Well, actually, the agreement was for ISF cognitive trial.
Okay.
Realized he'd already passed.
Yeah. So we've got 2 deferreds on those 21 cases. 5 years. Okay. In cause number 25 DCCR 0520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but probate that, place you on probation for 10 years. That's what your agreement is. I am going to order a $250 fine in that case. And I am going to order that you serve 180 days upfront time. And there's not going to be credit for the time you've sat, because I want you to see what it feels like to sit somewhere other than Jefferson County Jail. All right. And cause number 21-38934. Find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case. In cause number 22-39131, also find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case as well. And then finally, in cause number 23 DCCR 0899, find that you entered those pleas of true, freely, and voluntarily. Find sufficient evidence to revoke your probation, but I'm not going to do so in that case either. I am going to continue that probation. Cause number 21-38934. That's the evading arrest or detention with the use of a vehicle. So that's that first evading. I am going to, I'm continuing your probation, but I am going to extend it by 2 years. All right. So that's now a 7-year probation instead of a 5. Make sure to make that note. And then the other ones, I'm going to leave that other one. Okay. All right. So I'm going to hand you the trial court certifications in each of these cases, Mr. Smith, if you don't mind. This shows these were agreements that I followed, and so you waived your right to appeal. This new case, I want to make sure, again, that we're very clear that if you violate any condition of probation from this point forward, you are looking at a 10-year sentence in the first evading, 2 years state jail in the first unauthorized use, 2 years state jail in the theft, and 10 years that you just agreed to in this case. Do you understand? So it's very important that you do everything. It sounds like Ms. Joseph believes in you and that you can do what you've showed that you can follow the rules in jail and for some time out of jail, but you've got to follow the rules all the time or you're going to end up in prison, and nobody wants that. All right. So take advantage of this situation. When you get out of doing your upfront time, go straight to. All right, sir, you are Tyron Henderson.
Yes.
And Mr. Henderson was previously in court. We've got 3 MTRPs and a new case, and he entered pleas of guilty, or a plea of guilty in that new case and pleas of true to counts 1 through 6 in each of those motion to revoke probation cases. I've received a pre-sentence report, updated. Wait, is there a 5th one? Or just 4?
There's 4 cases. 3 MPRPs and
That's right, something was just printed twice. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
yes, sir.
Are there any additions or corrections?
Not from the start.
Not from the detention.
So I'm a little, well, probably a little more than a little concerned about your ability to be successful if I put you on another probation, because you were on probation for 2 cases, an evading and an unauthorized use of a vehicle from 2021. Then you pick up a felony theft in 2023, keep you on probation, add a probation on that case. So now you've got another felony while you're on all of these probations. And you've already been to ISF. I just need some help here. And Ms. Joseph is here. Ms. Joseph, what's your thoughts?
I believe that Mr. Henderson is satisfactorily complete his probation terms, even with the addition of another term. Mr. Henderson, from the start, and I had frank conversation with him about his current situation as well as the subsequent offense. He understands the seriousness of it, the unnecessariness of this event, and he offered no excuses, which is refreshing. When I notified him of the warrant, he did not hesitate, and he turned himself in. When I spoke with him at the correctional facility, he stated that he would accept whatever the consequences were or would be.
Well, and another thing, Mr. Henderson, which is a bit of a breath of fresh air around here, is you have absolutely no jail reports. And with the group of young people your age out there, that is pretty amazing because they're acting like fools, aren't they?
He's been in actually for 120 days too, so it's not just a short stint.
So the recommendation is ISF again, which I'm not opposed to. I'm sorry?
A state jail sanction for 180.
Okay, that's not what it says on here.
Well, that was my recommendation.
Is there an issue with misuse of drugs?
No, it's cognitive.
Safety's just, safety's,
I didn't recommend ISF. I recommended 180-day state jail.
just 180 days
Yes,
upfront
that's-
time.
He's already been to ISF.
I
so
know.
I don't know why we would repeat that, but that's why I recommend
Same. Okay,
state jail.
go get a feel for what it's like somewhere other than our
Yes,
jail.
yes. And we discussed that. I told him that's my recommendation, and he was willing to accept it.
All right. What do you think, Mr. Henderson? Do you have anything to say?
Judge, can I just say one thing briefly?
Mm-hmm.
He has been in for 120 days. He's had no write-ups. To his credit, every time I've met with him, he's accepted responsibility. He knows this is not a second chance, but a third and fourth chance that the court's giving him.
It's
He's
the
not
last
sentenced-
chance.
Yeah.
That's what it
He's
is.
not a sinister young man. He knows that he's made some really foolish mistakes. This last thing was him doing wheelies on a dirt bike. But I do think that he is someone that can be successful in probation. I think that he realizes too that this is not the path he wants to go down. And with every report, everything he said, he's accepting responsibility.
Yeah.
He knows he's messed up. And I do think he's somebody that, Judge, I really do think we're not going to see him.
I guess set for an announcement. Were y'all, before we go any further, were y'all able to work out getting everything discovery wise, that anything that was an issue?
Yes, Your Honor, we've received discovery and I've reviewed it.
Okay, perfect. And so what is the announcement?
We're ready to proceed.
Okay, and so there's no agreement?
We haven't really discuss that. I don't think he's going to accept any revocation offer, Your Honor.
All right, so what we can do is just go through that motion, get pleas are true or not true, and then we would reset it for a hearing on sentencing, get a pre-sentence report update done. Does that sound like what we need to do?
I think so, Your Honor.
All right, let me get this.
Yes, Your Honor, he does want to stay. I just checked with him this morning again. He wants to stay on probation.
All right, so we'll go through that motion. Let me get it pulled up the right way. Mr. Sanchez, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Speak up, please.
Yeah, Don.
Thank you. And will he waive the formal reading of that motion?
Yes, Your Honor.
Let's see. All right, Mr. Sanchez, I have a motion to revoke your community supervision. Shows that you were placed on probation September 30th of 2019 for the offense of driving while intoxicated, a third-degree felony. That was an 8-year sentence in prison, but it was probated for 10 years. Is that correct? I need everyone to please hold it down. If you're talking to a DA, that's fine. Everyone else. Mr. Sanchez, is that correct? Okay. Thank you. Count 1 in this motion alleges that you violated your probation by committing the new offense of driving while intoxicated, third or more, April 15th of 2025 in Wharton County, Texas. And is that true or not true?
Yeah, Don.
That's true? Okay. Count 2 alleges that you failed to provide verification of having the auto ignition interlock system on your vehicle. Is that true or not true?
Yeah.
It's true. And then count 3 alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were intoxicated April 15th of 2025. Is that true or not true? It's true. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Okay. And did you plead true to those counts because they're all actually true?
Yeah.
Okay. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case so that the probation department can do an updated report and give me more information about what's been going on probation and all of that. And then we'll come back at a later date for sentencing. If there's anything that you think is important for me to know, get that information to Mr. Franklin and he will present it to me on your behalf when we come back. Do you anticipate
I don't
any
see-
witnesses
with the-
or
with the
anything?
Pleaded true, Judge. I'll just wait and see what the report has to say.
Okay, sounds good. We'll reset it for sentencing. Thank you.
Thank you, Your Honor.
We need to get his fingerprint while he's here, please. Unagreed, yes, ma'am. Yes, thank you. Let's see, is Mr. LaGrop here? LaGrop on Courtney Joseph? Courtney Joseph. Good morning, sir. Say, how do you pronounce it? LaGrop or LaGrop? LaGrop, okay. I was right the first time.
I recognize you were in here, I think.
I've been in this court.
We've been here for,
Yeah, it's been like 7 or 8 years since I've been here now. This time it's not a family member. That's
oh,
It's my brother. They
I feel like
dismissed.
now I feel like I
Money to
remember.
get it dismissed.
I feel like I remember some vague memory of that.
And I didn't know if you knew a bunch of you knew some of my cousins. See, all my whole family was brought off.
Yeah. Oh, are they?
Yeah, they all went to TJ.
Oh, yeah.
My uncle, Wesley J.
My husband went to TJ.
He coached, he was principal and Bum Phillips was the coach
Oh,
30 years. So I had 15 biological uncles.
oh, wow. That's a-
Agents.
Okay, as soon as she's on the other side, they'll walk her down. As soon as they get her down, we'll take care of this. And this is just a bond hearing for the motion, right? All right. Oh, never mind. Come on back. Let's see. Pull this up.
Oh, cool.
All right, this is cause number 23 DCCR 0167. And are you Courtney Joseph? And so Ms. Joseph is on probation for assault on a peace officer. That probation started on December 11th of 2023. It was a 5-year deferred probation. A motion to revoke that probation has been filed with allegation of driving while intoxicated with a child passenger. I guess there must have been at least 3 of those passengers because there's 3 charges. Violation of committing the offense of resisting arrest. Allegedly left the county and was in Orange without permission. Out past court-ordered curfew. The new offenses alleged were at 10:17 p.m. in Orange, it looks like, yeah. And behind on fees. And Mr. LaGroppe has filed a motion asking that a set a bond. It is a deferred probation, so typically a bond would be set depending on certain circumstances. So Mr. LaGroppe, I will go ahead and let you want to call your client, or if you would, ma'am, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
And I'm just going to question her about her financial circumstances.
That's fine.
Okay, how long have you lived in Jefferson?
Since 22. August
Speak up some for me and for the court reporter, please.
August 2022
Okay, where did you live before that?
in Orange, Texas.
How long did you live in Orange, Texas?
Almost 2 years with my grandmother
And where did you live before you lived in Orange, Texas?
in Courtroom.
Hold on. How long did you live in Courtroom?
For 3 years,
Let me ask you this, where were you born and raised?
Orange, Texas.
So you lived in the general area of Jefferson County, Orange, Texas, and Port Arthur since you were born, huh?
Yes,
Okay. Have you ever moved out of state or anything like that?
no,
How many children do you
we have 5.
have? And where do they all live?
With me.
What type of work were you doing when you were on probation?
I was in care provider.
Care provider. Explain to the judge what you mean by care provider.
I provided for an elderly man. I cook, clean, 3 hours a day, 5 days a week.
How much money were you making with that?
Just $8 an hour.
How much money approximately would you make a week?
How much it's worth? So like 140.
And so you make about $140 a week.
Yes.
So you would total about $600-700 a month.
Yeah.
Okay. Where do you and your children live?
On 8th Street.
Do you live with your family or do you live by yourself?
Me and my children, my mom just moved back in.
So your mother just moved back.
Yes.
Before the allegations that are alleged in the motion to revoke probation, who were you living with at that time?
Just me and my children.
Okay. You and your sisters?
Me and my children.
You and your children. If you're only making $600 a month, how are you paying rent where you live?
I also get Social Security survivors. My children's father that passed into me.
And how much money do you get for survivors?
$780.
$780 a month. Okay. And approximately how much money do you have right now?
I don't know.
No? Okay. If the
Speak up.
I get paid around the 15.
How much money will be coming in?
$780.
And so if the court were to set bond at a reasonable amount, okay, would you show up for your court appearances?
Yes.
Okay. You understand the allegations against you, right?
Yes.
Okay. And you're gonna have to appear in Orange County, correct? What's the county of Orange? I can't-
Orange, mhm. It is.
I should know that. Orange County, so what was your bond set out in Orange County?
3
3 what?
3,000.
Okay, 3,000. So, and did you post that bond?
Yes.
Have you had to show up for court yet for that yet?
No,
When is your next court appearance for that?
I have no idea. I was calling every Monday as I was supposed to, and then when this one came in, I turned myself in.
And you did once you found out, you talked to your probation officer, they told you they were gonna file a motion to reopen, right?
Yes,
And you reached out to me, correct?
yes,
And then you turned, and they had to schedule a meeting for, I think it was July 31st,
the 31st, 49.
and you turned yourself in the day before,
Yes,
correct? And you knew you were gonna be arrested if you came.
I'm pretty sure.
Okay, I pass on.
Any
I
questions?
have no other questions for purposes of this hearing. Your
All
Honor.
right, any other witnesses?
No.
Mr. Nichols, what's the state's position on
I don't mind
this?
the court setting a reasonable bond in this case, Your Honor. I just want there to be sufficient conditions in place to keep her from driving, and she needs to, I think, have an alcohol monitor of some sort. I'll note, all these violations except for the fees and stuff, all are one incident. There's not a history of testing positive or anything like that. So whatever the court sets is fine, as long as we have those restrictions that we need.
Okay,
Can I elaborate?
yes, sir, please.
Very minor amount. Her mistake was she went to a family gathering. That's why she left the county. That's why she left to go to a family gathering with all the ritual. That's wherein the rub lies. Bad judgment, Your Honor.
Very, especially while you're on probation for a second-degree felony. So what I'm going to do is grant the motion. I'm going to, is there an order? I'm going to,
I'll follow.
okay. Let me look at one thing real quick. I'm going to set your bond at $20,000. A condition of that bond, if you make it, will be that you will be required to wear a scram device. And that is a monitor that you wear on your body at all times that will alert if any alcohol is consumed at all. Obviously, you will be ordered to remain in Jefferson County, Texas. Just like before, if you leave Jefferson County for any reason without permission, your bond, we're not gonna be talking about a bond again. You'll just be sitting in jail waiting on all of this. Do you understand?
Yes.
If you test positive for alcohol, then you're gonna end up right back in here. You understand that? Anything else?
I think that's sufficient.
All right, well, if, we'll reset it for a regular announcement and see where we get at that point.
And
All right,
I'll track.
okay. Thank you, sir.
Orders.
Thank you. Mr. LeGros, if you want to just email the order.
Thanks. Thanks.
Mr. Macon, you've got Ronald Spites.
Yes, Your Honor, it's a bond. Okay.
Everybody wants to get out of jail.
Yeah. Good morning, Your Honor.
Good morning. How are you?
Well, yesterday I spent all day in Houston with doctors, so
Mm,
I'm glad to be here.
we're glad you're here.
But, as I've said before, getting old is not for young people.
Good morning. Are you Ronald Spites? And Mr. Spites is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me,
No, he was arrested for murder and indicted for manslaughter.
Intentionally and knowingly causing the death of an individual.
let me look at the indictment. It shows, I don't know why the heading
Heading says manslaughter, but the language.
did then and there
knowingly, not
intentionally
reckless.
and knowingly caused the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can, take care of that later. So based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at 800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ron James Spikes.
And Mr. Spikes, you're the person charged with the offense.
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
Yes, sir.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors. But in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family, and things.
Okay, and your family, and you have a job, were you able to make funds?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez,
Yes,
correct?
sir. Yes,
And that's at 365 Scrap?
No, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment?
Yes, sir, I do.
So you've always been working, you know?
Yes, I have.
Do you have any assets whatsoever? Real property, coin collection,
No, sir.
anything like that? And you're asking the court to set some reasonable bonds so you could get out and go?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, he served 4 years CEC. So whatever, if it's murder, he would be 15 to life at least. And if it's manslaughter, it's about state court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it.
Okay. Can you take a look at this real quick? And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998, 4 year sentence.
All right, to possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to 500,000. Sir,
No,
did you want to say that again louder?
I believe no story. I ain't say that. I ain't say that.
You did say something.
Well, I didn't say nothing to it.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right, sir? That's what it's set at right now. All right, you can go back with the bailiff. What?
I'll be back.
Ms. Perazzo, you have LaCaven Jenkins. Good morning. Is he pleading to the indictment as it is, or is there any?
It's as is, Your Honor.
Thank you.
Mr. Sorry. Philip said that the discovery exhibit for one of those is being sent by Sarah since I didn't have it.
Okay, thank you. Thank you, Mr. Smith.
Sorry.
All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with the first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 24, DCCR 1027, you're charged with the third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Is there a, I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty. And at this time, find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to be elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? See, state tenders number 1.
Objection, Judge.
It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony. Sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. See, Mr. Lewis, you have Kevin Tran. It says it's locked. Thank you, and bless you too. I know. All right, are you Kevin Tran? And Mr. Tran, in clause number 2137560, 2138780, 25 DCCR 0422, 25 DCCR 0423, 25 DCCR 0424. I'm going to take judicial notice of the files in all of those cases. Looks like the first 2 cases, he's on probation, and then we've got new offenses as well. Mr. Tran was evaluated for competency to stand trial by Dr. Grapon. I received that report dated July 21st of 2025. The finding in that report is that Mr. Tran is currently not competent to stand trial, and that inpatient restoration would be called for. Is there any other evidence with regard to competency?
Nothing, Judge.
No, Your Honor.
All right, then based on that report at this time, I am going to find that Mr. Tran is not competent to stand trial, find that inpatient competency restoration is required, and order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report. Mr. Tran, we're going to try to get you some help so that you can understand everything that's going on, and then we'll get you back in court as soon as we can. You can go back with the bailiff. And then you've got a Michael White.
Yes, ma'am.
Mr. Let's see. He's already been and come, now he's back.
He's back, but he's not.
He's still, they don't believe he'll even be restored.
He's going to be restored.
Okay. So,
You guys have extra insurance, that's right.
all right, you're Michael White. And this is cause number 24, DCCR 0782. And Mr. White was previously found not competent to stand trial, sent to the Dunn Behavioral Science Center. And we received a report from them dated April 4th of 2025. That report is from Samantha Guzman, and the opinion in that is that he is still not competent to stand trial, with the finding that outpatient competency restoration could potentially be something that would work for Mr. White. The problem with that is that we don't have an outpatient competency restoration program. And so, and that he's not likely to achieve competency. So I don't know exactly where that leaves us. Mr. Smith, what's the?
Judge, I believe his mother lives in Florida. She's willing to take custody of him. And I believe they have a program that is along the lines of this with outpatient competency restoration.
Yeah. Would we do that through a civil, or would it be a dismissal?
That was the question I had on you. We're willing to do whatever it takes to get him there.
And Judge, if I may, I've been talking with his mother. She's been in contact with the probation department there, just trying to get them familiar with what kind of programs they have. They have a program there called the Gateway Program that works with their mental health department. That's basically similar, goes along parallels to what this would be. And the only issue that they've been having to try to get information on Mike is, my understanding, they can't do the interstate compact without it having an out date or anything when they would be getting out to leave to go down there.
But I can't, is this a motion or is this a new case?
It's a motion, because he was sent back from ISF, Judge.
Yep.
Okay.
He was sentenced to ISF as a term and condition of the probation term.
Mm-hmm.
He got to ISF and then started to regress.
Right.
So I can, without pleas of true or not true, really, I think on that motion, I think we can just order that he live in a certain place, which would be with her, that he participate in those programs, and then the probation could transfer to that, correct? I mean, we can't do obviously any kind of pleas on anything.
No,
So it
I
would
agree.
require a dismissal of the motion to revoke.
I don't know, do we actually have a motion filed? I believe we just had this set for hearing because he was returned from ISF.
Gotcha. Okay. So then we just need probation to do the, I don't know if you would necessarily take an administrative hearing or just send in me the order to sign, ordering the Gateway Program through, and if you can get the county and the address of it, where his mom lives, and
I
you get
got
all
her
of that,
address and that information this morning, so I
you can get all that to probation. Does that sound like something we can do? Okay, well, let's do that then. We'll just not go forward with anything, motions here. Let's just, whatever conditions you need to add with regard to him being able to go there. And then we can kind of figure out when that's going to happen so that they can get transportation. So if you'll work with probation, y'all get all that worked out.
Okay,
Okay?
no problem.
All right. We're going to get it where you can go live with your mom in Florida, okay? But you still have to follow the rules. Nope. I don't know if that's a good thing or a bad thing.
He's thinking you like
He's like, oh, no, not my mom. Don't make me go to my mom. Let's see, Ms. Holmes, you have Jamel Caddy. She must be in the back. Let's see, Mr. Parker, how about Alfredo Gayton?
You have that, Judge.
Alfredo Gayton? We have so many hearings this morning. Morning. Y'all marked second degree.
We're going to proceed on at least one of the priors to the court's permission. It is not something, there are additional priors that would enhance him that are not required in the underlying. If that makes sense. Jurisdictionally, they're not required, but.
Let's see, so it looks like there's two, the first two are, well, we've got a,
So he received 5 years TDC on the 93 case and then 90 days on the 98 case. And then my position is that at least that 2004 or the 2009, whichever the court would like to recite, would enhance him from the third to the second.
so he'll plead on all, let's say, except for that last one, because that would actually enhance it again.
Yes.
All right, so you'll waive the March 3rd, 2009. We won't go on that, but everything else. Does that make sense to you too, Mr.
Yes, ma'am.
Parker? All right, sir, are you Alfredo Gayton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor. I give you.
Mhm.
Okay.
I think so.
Yeah,
I think I already
did.
signed it and
Okay.
handed it over. Give me just a second to get this pulled up. Mr. Gayton, in cause number 25 DCCR 0184, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's for March 30th of 2024. The indictment alleges you were previously convicted of driving while intoxicated September 28th of 1993 in Harris County, Texas. And then after that, and then on July 9th of 1998, convicted of driving while intoxicated in San Patricio County, Texas. And then after that, you were convicted on July 28th of 2004, again in Harris County, of driving while intoxicated. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a cap of 14 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. You can have that jury decide if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right, and you're leaving your punishment up to me. And as long as I don't give you more than 14 years, then you're waiving any right to appeal. Do you understand? Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gayton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. find sufficient evidence to find you guilty. However, I'm going to restate your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right? You can go back with the bailiff. Thank you.
She didn't have that money.
Sean Harley, Mr. Parker. Huh?
Just didn't want to see it.
Okay.
So I wouldn't be surprised if he changed his mind. He said he wanted to change his mind, but we got to change it. We'll take it back.
Good morning. Are you Sean Harley?
Yes, Your Honor.
And Mr. Parker, will your client waive a formal reading of the indictment in each case?
You will, Your Honor.
Mr. Harley, in cause number 24-2148, you're charged with the state jail felony offense of criminal mischief. And that's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then in cause number 25 DCCR 0739, you're charged with a third-degree felony offense of harassment of a public servant. That's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they've charged you with?
Yes, Your Honor.
In each of these cases, I have here on the computer some documents that have your signature on them
Yes,
that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Harley is not competent?
No, Your Honor.
All right, Mr. Harley, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily.
Yes, Your Honor.
Find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 2148, find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0739, also find sufficient evidence to find you guilty. And at this time, find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each case that shows these were agreements and that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Kashawn Pugh, Mr. Parker.
That last guy, I thought, they're running CC, what cases in jail, in probation, he didn't do probation.
Because what?
Because he thought that his time that he served in jail right now would run CC, that it would eat up his case. He only has 2 months in his case after that. I mean, I explained to him for 45 minutes.
Judge, on this, we have a plea in the new case and an offer on the probation of the court would accept it based on the reasoning that he has no prior felony history.
Okay. I'll probably do an, I might do an update.
The motion is on the state jail.
Oh, I
New
see.
cases.
Okay, and it's not to
It's for
continue. Okay. All right, are you Kashawn Pugh? And Mr. Parker, will your client waive the formal reading of the motion and the indictment?
You will, Judge.
Mr. Pugh, in cause number 23, DCCR 1531, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from June 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? Answer out loud, please. Thank you. The court reporter has to take everything down. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. And Mr. Pugh, you are a U.S. citizen, correct? Is there any evidence that Mr. Pugh is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Let's see. And then in cause number 19, 33356. Give me just a second. Yeah.
Kim just realized we have Adams. I don't know if you need it or not since they came up.
No, not since they came up with
Okay,
something. Thank you, though.
Yes, ma'am.
Actually, let me see that again. No. What I'm looking at right now is your jail incident reports. You don't like being told what to do out there, do you?
That's not the issue. People come to work with problems of their own.
Okay, so it's the correctional officer's faults that you don't follow the rules?
When I walked across the dorm and gave a guy his bowl, I did that. I was working out in the bathroom, I did that.
Okay,
Miss Painter, she called me on my name multiple times, and I asked her to identify herself. The other things that she wrote in there about me were not true. I had another officer read it to me, so I know what it says.
Okay. There's only one.
Mr. Washington wrote me up, and that was a lie. That's why I got moved to orange, because I actually was in blue at first.
Mhm.
And the lieutenants don't even know why I was in there. I was actually in Indorm, placed in Indorm under, so to say, Stroder's advisor, but Stroder never wrote me up, so I don't even have a write-up for that. They
Okay.
don't have that in there either.
Okay. I mean, it sounds like you're saying you did most of what they're saying you did
No, I
wrong
didn't do
anyway.
most of what they're saying at all. Most of those write-ups, Washington and Painter,
Mm-hmm.
and I think another lady, I didn't do the other things that she wrote up. Butte wrote me up for some other things, and I told her that I can't do her job for her. She wanted me to point somebody out, and that was she just wrote me up on it. So.
Okay. So Washington didn't tell you to stop talking,
No, ma'am,
and
he
you
didn't.
responded by saying, quote, "Officer, you telling me we can't talk in the bunk area? You tripping." You didn't say that?
I did not. That man did not tell me nothing that whole day. He didn't. And when I asked him if I had a write-up, he told me no. And then he actually wrote me up 2 days after they moved me from blue to orange. That wasn't even the same day.
And you didn't go to the restroom and wash your clothes in the sink, and he
No,
told
ma'am,
you
I
not
did
to do that?
I did not do none of that.
You just made all that up?
I swear, I asked the lieutenant to check the cameras and see if that's what I did, and she didn't want to do it. So that write-up was just for nothing. When I asked him if he wrote me up because they told me that I had a move card, I said, "Why am I moving from blue to orange?" He said, "I don't know." And I was like, "Well, did you write me up for something?" He said, "No, I didn't write you up. The lieutenant called and said that you had a move card, that they were placing me in my right because I have a felony case that I'm supposed to be in orange." And when I came in at first, I told them that I was supposed to be in orange, but they put me in blue and told me that they were.
Sounds like you know their job better than them, huh? You're just out there telling them what to do and where you're supposed to be and all that kind of stuff. See, here's the thing. I don't have to accept any agreements in here. And I know word out there, it's got to be getting around that I'm not accepting agreements. I'm putting people back in jail because of these incident reports. Because these people are just trying to go to work and do their job, and they don't need you or anybody else telling them how to do their job, where you're supposed to be. You're supposed to be where they tell you to be. You're supposed to wear what they tell you to wear. That's part of being in jail. You don't get to make your own rules. Stop breaking the law and you can do what you want and wear what you want when you're out. Does that make sense?
It does make sense.
All right, so in cause number 19-33356, I have a motion to revoke your unadjudicated probation. This one shows that you're placed on probation December 7th of 2020 for unauthorized use of a motor vehicle. That was a 2-year probation. Looks like it was extended at least once. Is that correct?
Yes, ma'am.
Okay.
It looks like this motion Judge, was filed in 23, so that needs to be worked on. He's just been at large on it since.
Okay. It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, June 18th of 2023. And is that true or not true? True or not true? True. Count 2 alleges that you failed to report as directed to the probation department, April 10th, May 22nd, and June 12th of 2023. And is that true or not true?
True.
Count 3 alleges that you didn't work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
I'm sorry?
Not true.
Okay. Count 4 alleges that you failed to immediately report to the probation officer a change of address and your arrest. Is that true or not true?
Not true.
Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of participating in the education program for your GED. And is that true or not true?
True.
Count 7 alleges that you failed to provide verification of paying court-ordered child support. Is that true or not true?
Not true.
Count 8 alleges that you're behind in your court-assessed fees as of June 26, 2023, in the amount of $2,361. And is that true or not true?
That's true.
So he was at large since 2023? Is that what this, I would assume from this? Since there's,
That's what I would assume, Judge, just from the file stamps and the fact that his last admin was in 23 as well.
so did you just stop going to probation back in 23?
Yes, ma'am.
That's after he got arrested on the new case, apparently. But that's what it appears, Judge.
No, that was before I got arrested.
Yeah, the new case is from March of 2024. So you had already stopped going for
Yes,
almost a
ma'am.
year.
Because she was planning to violate me for
This
any
is-
reason, I don't know why.
June of, it says June 18th of 23, I thought.
I'm sorry, I'm looking at the wrong thing. Hold on. Looking at the wrong thing.
It's supposed to be.
2023, June 18th, yeah. Stopped reporting in April. New offense in June. I don't know if I like it or not. Guess it really doesn't matter a whole lot just because it's gonna, I already gave them the 3 on the other one.
We can rediscuss it, Judge, and raise the time.
I'll do it. All right, so I'm going to find that you entered your pleas of true to counts 1, 2. Well, let me go through this first. I have also in this case, on the motion to revoke case, some documents here on the computer that have your signature on them. Did you also go over these with Mr. Parker? And you fully understand them?
Yes, ma'am.
Again, you understand if I follow this agreement that you'll be waiving or giving up any right to appeal.
Yes,
State tenders number 1.
No objection.
It's admitted. All right, I'm going to find that you entered your pleas of true to counts 1, 2, 5, 6, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certifications, and each of it shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Daniel Turner, Mr. Parker,
These guys try to talk their stuff out of a plea.
this one?
No.
Oh, I know. Yeah.
At first he wanted to. This guy.
He's pretty lucky he
This guy's
did.
nervous. I said, no, I said, you need to change it for the mission. How are you?
Good morning.
Good morning.
I understand.
Good morning. Are you Daniel Turner?
He's
And will your client waive the formal reading of the motion?
He will, Judge.
Mr. Turner, in clause number 22-41012, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 10th of 2023, and that was for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct? The motion alleges in count 1 that you failed to comply with the orders of the McLennan County Probation Department by not making consistent payments towards your financial obligations. Is that true or not true? Count 2 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department by mail or reporting online for the months of May, August, September, October, November, and December of 2023. And then January,
The whole year of 24.
yes, the whole year of 2024. And then January, February, March, and April of 2025. Is that true or not true? Okay.
And Your Honor, if we could just skip to 6, I think in light of our agreement.
Y'all
that'd be
wrote 1,
sufficient.
2, 3, and 4.
I meant 6.
You meant 6?
Yes, Your Honor.
Okay.
Sorry.
Mind if I make that
No
change?
objection.
No objection.
And then the state's elected to go forward just with 1, 2, 3, and 6. Count 6 alleges that you failed to provide verification of attending and complying with all of the treatments through the Heart of Texas Behavioral Network. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Turner is not competent? All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir.
No.
Did you have a question?
I thought I was.
1244. You got a 1244, so you're going to serve your time. You got a felony conviction, but you're serving your sentence in the jail.
So I'm still on.
Yes. Yep.
Judge, I pivoted to that other charge just to make sure the mental health was addressed too, because that's an issue on it.
That's what it looks like. Thank you. See, who's here? Mr. Wilkerson's here. All right, is Miss Holmes in the back working, I guess? Maybe Mr. Wilkerson, let's take care of Larry Fletcher.
You want to set the bench, John?
How many witnesses? How many?
4 or 5.
Judge, if it would help, the state is amenable to making certain stipulations
if it will cut down the time.
Sure.
In witnessing.
So are you Larry Fletcher?
Yes, ma'am.
And so, Mr. Fletcher is on probation and cause number 21-37809 for the offense of possession of a controlled substance, a second-degree felony. That probation is from October of 2021. It was a 5-year deferred probation. And then it looks like we have 2 new offenses that have been indicted in cause number 25, DCCR 0838, an aggravated assault with a deadly weapon, and 25 DCCR 0839, a manslaughter charge. Mr. Wilkerson has filed a motion asking that I set a bond in the motion to revoke case.
Yes,
Is there,
Mr. Fletcher.
hold on, is there any motions in the other 2, or we're just talking about the,
I believe the state filed a motion seeking to actually increase the defendant's bond.
in which
Your Honor.
case?
No, I filed in both cases. In the NQRP, we filed a reply to the defense counsel's motion to set a bond. And then in the other 2 cases, the state, the aggravated assault and the manslaughter case, the state has filed motions to increase it.
Let me get that all pulled up real quick and then we'll get started. Hold on. I'm printing. I needed to see all that. I just printed the response in.
Okay, I'm sorry, I thought I printed it all for you.
It's okay. We'll get it.
Trying to make some trees.
It's your fault.
That's all. It always is. In my mind,
I'm used to taking.
in my mind, it's always my fault.
Are the PCs, I guess, would be the same in
For the
the manslaughter and the ag assault. So I'm just
It
printing.
came out of the same transaction.
Okay,
Occurrence, Judge.
give me just a second.
Yes.
Hold on. All right. So there's no bond currently set in the motion to revoke. The bonds in the 2 new cases have been set at $50,000 each. So I've got a motion to set a bond in the revocation, and I've got a motion from the state to increase the bond and or modify conditions in the 2 new offenses, correct?
Yes, ma'am.
Okay. With regard to well, I guess, Mr. Coleman, you mentioned that you would be willing to stipulate to some things before we get started with
I
witness.
suspect Mr. Wilkerson will call these witnesses to talk about the length of residency and the ties in the community, those kind of perfunctory things. If he will shorten this proceeding, I'm willing to stipulate to those if Mr. Wilkerson.
I mean, it to some degree, that is some of it, but obviously there are more intricacies involved, including the nature of the family, the length of work, things of that nature that I think all need to be put into play here.
And I don't mind hearing the evidence. I don't want to hear the same thing. They're here and I appreciate they're here and I'll take notice of that. But what I don't need is to hear from all of the witnesses the same thing about work and living and all that. So if you want to call 1 or 2 that have that information,
Absolutely.
that would be great.
Yes.
I just don't want it to be the same thing. And I'll take notice that they're here and that they would all say typically the same thing as if that's what it is.
He's on bond on 2 of those cases. I'm calling the bondsman right now.
Yes, he is.
He's already on bond. They filed a motion to increase the bond.
That's correct. So he, obviously this this very tragic accident occurred one evening. There is no allegation of any substance use on the part of Mr. Fletcher contributing to the accident that involved the death of one of the victims and the severe injuries to the other. There is some, I guess the state's theory seems to be on the manslaughter, that he was reckless in his driving on that evening, thereby causing the death of another in the course of that reckless behavior while driving, which then makes it a stretch when the state then moves on to an aggravated assault charge for the second occupant of the vehicle, because of course, if there were the intent and knowing element present there of course would have been a murder charge associated with the death of the first occupant of the vehicle. We are not debating, obviously, the tragedy of this incident, Your Honor. Mr. Fletcher, on the night in question, was actually responding to a work call. That is the reason that he was out on this particular evening. It was not after curfew. It was work related. He works for Ryder, the truck company. Judge, he's a mechanic. And as the court's aware, several years ago, Mr. Fletcher had an issue with substance abuse. Unfortunately, that's an issue that affects far too many people in the community, our loved ones, or sometimes ourselves, our family members, parents, sons, brothers, sisters, children. But Mr. Fletcher has been serving his probation faithfully. He has been supporting his defendants, Your Honor. He is engaged to be married. He has custody of his biological 2 children, and then also takes care of the 2 current children of his fiance, and is now welcoming a 3rd child. They are expecting that child. Mr. Fletcher has employment to return to, Your Honor, in terms of while these matters play out in the judicial system. Obviously, there are, the state seems to highlight Mr. Fletcher's driving record as a reason to change or deny bond in conjunction with the possession charge, which he is entitled to bond on. With regard to the driving record, I would simply say if that driving record, that, by the way, I have not seen certainly a certified copy of any driving record of Mr. Fletcher, but I have no reason to doubt Mr. Coleman's representations regarding that. There are certainly rules that the court could fashion. Obviously, Mr. Fletcher has a large family here supporting him, who have also been very supportive of the Thomas family since this tragedy. The allegation has to do in terms of Mr. Fletcher's fault in that death and that aggravated assault, which seems like a mighty jump in mens rea there, Your Honor, seems to be that he was traveling at such an excessive rate of speed on the night that when the person who disregarded the traffic safety device, and entered a lane, failing to yield right away. Mr. Fletcher then did not have sufficient time to react and stop the vehicle because of his rate of speed. Obviously, we haven't had an opportunity to have our own investigators take a look at any of that evidence to be able to argue it at this point in the case, Judge. I only mention it so that the court is aware of the background context under which these allegations arise, and the sole issue at present right now in the defendant's or in the defense's opinion is whether or not to provide Mr. Fletcher a bond on the charge for which he was serving a deferred adjudication sentence and for which he has not been convicted, thereby, of course, making him eligible for bond in such case. Obviously, Judge, the law has changed in a number of ways. And if this were a case where Mr. Fletcher were some violent person, prone to violent outbursts, aggravated assaults, as the state alleges one of these was, although I just don't understand how you.
I'm not going to get into the legal. I mean, they filed what they filed. That'll be a question for later. So
the issue here, Judge, is whether or not to grant him bail while the allegations that form the basis of revocation of this bond come to be addressed by the court. Your Honor, as I mentioned, and I would like to put his fiance on just briefly, his mother as well. And
let me stop everybody. Here's what I'm inclined to do. I am inclined on the two new cases, the ag assault and the manslaughter, to in part grant Mr. Coleman's motion and modify the bond conditions. I don't believe I'm going to increase them because I think I can modify them in a way that will hopefully ensure the safety of the community. What I'm going to do in cause numbers 25 DCCR 0838 and 0839 is modify the bond conditions in those cases in order as a condition of bond that Mr. Fletcher is not allowed to drive, period, ever, any vehicle while these cases are pending. It does concern me, the prior allegations with regard to driving. We've got 2010 a crash, 2012 a crash, 2012 maximum speed limit issued, 2013 speeding over 10% over, 2016 speeding greater than 15 miles over, 2018 another crash, 2021 another crash, and here we are with a crash where I'm not going to get into fault, but there is a crash and we've got someone that has passed away and someone that is seriously injured. So that if I'm going to require that, I understand there may be work issues and that is what it is at this point. That is what I'm going to order in those two cases.
And I can understand that, Judge, but I would point out that the same issues of fault that belie this case, we're also uncertain of what.
It doesn't matter to me. We're going to stop having crashes no matter whose fault it is. When there's a common factor and there's the same thing that continues to happen, I can't help but at least have some concern that there is at least some type of fault on some of those. You know, you don't get into that many crashes without something happening. Okay, so my job is twofold: keep everybody else safe in the community and to do what's right with regard to you and your rights as well. But I've got to keep everybody safe, and based on that history at this point, while the case is pending, unless something changes later with further order of the court, you are ordered not to drive. Okay. And so I think just by the nature of obviously that order, I'm probably inclined to grant the motion to set a bond in the probation case. And so I am at this time going to set the bond in cause number 21-37809. I'm going to grant the motion to set a bond. I'm going to set the bond in that case at, that's a possession. I'm going to set the bond in that case at $30,000. The condition of the bond is the same. You're not to drive any vehicle. And it doesn't look, I think Mr. Wilkerson is correct. I'm just looking at past administrative hearings that there hasn't been an issue with any type of positive drug screen or anything like that. And
Not administratively, just what he is accused of, in addition to the manslaughter and the aggravated assault, accused of violating his probation with the possession of a marijuana case and also UC.
so what I'm going to require is the condition of that bond on your MTRP case is that you wear a drug patch if you make that bond at all times. You'll have 24 hours from the time you're released to get a drug patch put on. You have to go change it every 2 weeks. On time, and it needs to be on there, can't sweat off or whatever. You need to make sure it's on and it's testable every 2 weeks. Obviously, if there is a positive drug screen for anything in your system, it's a violation of all of your bonds, and you'll be right back into custody with Mr. Coleman probably telling me I told you so. So make sure you stay clean, make sure you do get it changed when you're supposed to, and all of that kind of stuff. So that bond condition is the same on all three of the cases. All the bond conditions are the same on all of the cases. No driving and drug patch on all three cases. Anything else?
Just procedurally, Judge, ordinarily, we would defer with these types of charges, new charges, we would defer the MTRP, we'll wait on that and proceed on the new case, particularly as with how serious these are. However, in this case, I just want the court to know that we would be looking to go forward on the MTRP first.
Okay.
For a number of reasons. So we're looking to amend that MTRP. We'd ask that it be set prior to a disposition in the new manslaughter or.
And you would be intended on putting on evidence of those new offenses in that hearing? I would.
For punishment, the punishment part of it is.
I mean, to prove up the MTRP.
We have other things that prove up the MTRP, particularly the possession of marijuana, also the UCW, but there very well may be some additional testimony about those circumstances surrounding
So there-
aggravated assault.
There obviously appears to be some additional information, or maybe just because of the size of the cases, I haven't had an opportunity to review everything.
Yeah,
But
so-
there are some allegations that I'm hearing have not been at the forefront.
So let's do this. Obviously, you need some time to get all that information. If there's going to be an amendment, if you'll please take care of that quickly, make sure anything that's alleged in that Mr. Wilkerson gets any discovery with regard to any new offenses or alleged offenses that you intend to put. That way you guys can both have all the information. Mr. Wilkerson can do what he needs to with that information, and we'll set it for an announcement. And then we'll kind of go from that announcement on where to go next with regard to either the new cases first or the motion first. All right, sound good? All right, thank you. Y'all are excused. And thank y'all all for being here. I don't want anybody to think, I feel like we could cut it a little short and get that taken care of. All right, you go back with the bailiff.
Thank you, Your Honor.
Yes, sir. Do I have, okay, so I've got an order. I need to write all that on something.
That was 1:30, Judge.
Yeah, give me just a second. So y'all got it all written down. I'll sign some orders later. Just make sure I sign everything I need to and put those conditions on them. Okay. Let's see, John Jones,
Yes, Your Honor.
2 cases, that is also bond hearing. Did you receive the jail incident reports?
I did see some, Your Honor.
You might want to take a minute to review those before we go forward with your client, because they're going to be something I definitely have an issue with, all right?
I can understand that, and I did have an opportunity to browse.
You did?
I got
Okay.
them yesterday. I browsed through some of them. We did meet briefly yesterday as
Thank
well,
you.
so.
All right, sir, you are John Jones?
Yes, ma'am.
And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And Mr. May. And in cause number 24 DCCR 2431 with the offense of unauthorized use of a vehicle. Mr. Wilkerson has filed a motion just in the murder case, correct?
Correct.
That I reduce the bond.
Yes, Your Honor. Which I believe is set at 800, if I remember.
Let me pull it up so we make sure. Let's see.
Misquote because I have had several of these.
It looks like in the motion, it shows that
Just a murder.
the murder is set at $800,000. And Mr. Wilkerson, do you intend to call your client or other witness?
Your Honor, I just intend to call my client, and then also Benicia Jones, if she is still present.
Mr. Johns, best you can, raise your right hand. Or Jones, I'm sorry. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can go ahead, Mr. Wilkerson.
Ms. Jones, you are obviously the same John Jones charged in this case with murder. You also have a companion case in which you are charged in a separate offense with unauthorized use of a motor vehicle. Is that correct?
Yes, sir.
And how long have you been incarcerated?
About 4 months.
And during that time, has that time, you had the murder charges pending during the entirety of that time, is that correct?
Yes, sir.
Now, the person who actually pulled the trigger with regard to this offense has pled guilty and been sentenced, is that correct?
Yes, sir.
And that was to 30 years, is that correct?
Yes, sir.
And he was on parole at that time, correct?
Yes, sir.
And until previously, at least as of the 24th of July, you had been off of 35, correct?
Yes, sir.
All right. Now, during the time that you have been incarcerated, you have had some run-ins with staff with regard to some behavioral issues. And obviously, if the court is going to consider lowering your bond and how you would be able to behave or would behave in the community at large, were she to grant a reduction in your bond, there are some concerns. And so I would like to give you the opportunity to speak to those concerns, and I would encourage you to emphasize conditions that the court might be able to impose that you would be ready and willing to follow that might curb some of those concerns for the court while this case remains pending.
Yes, sir.
Go ahead.
Let me say, while the write-up thing was going around, I didn't have my proper medications, but I was supposed to be seeing a psych nurse to take my proper medications. And I feel like if you was to give me a bond reduction, and I was to get those recommendations, and I was to make bond, I'll follow the rules, because I take my medications now, which are for my anxiety, depression, and things of those nature. So I feel like a bond reduction is necessary, but
So you have your medications now?
No, but I should have them by the 21st.
So anxiety and depression don't make you say things like,
Not even gonna sit here in front of you. I've never said those things, but
you didn't say those things?
no.
You didn't ask her how could she have a boyfriend with how ugly she was?
Never said.
You didn't ask how many boyfriends she ever had? You didn't say any of that. They're just making that up on you, just lying.
I have to.
Have to be lying. You didn't threaten just a couple weeks ago an officer that you were going to throw hot water if she didn't call somebody?
Yes, ma'am.
You did threaten to do that? Okay. Did you say at one point when y'all were getting in trouble that what it had to do with somebody giving a Bible back to another person, and you inserted yourself in something that wasn't about you, and you said, that's what's wrong with y'all officers. Y'all think we on y'all time, and I'm not. So you don't think you're on their time when you're in jail?
I never said that.
You didn't? They made that up too?
What I said was, respect is given both ways. That was my exact words.
Respect is given both ways. And so you think you deserve respect with how you're acting. I got pages of incident reports, and it's pages only starting in June. We're talking about pages over just the last 2 months. Fighting. You've been in at least 2 or 3 fights, right?
Yes, ma'am.
Yeah. Mr. Coleman?
Your Honor, I have just a couple questions. Mr. Jones, what did you do with the weapon after Lenny Nixon was shot?
I gave it back to Green.
And when did you and Green decide to rob Lenny Nixon?
Objection, Your Honor. These questions obviously go to the guilt innocence aspect of
I
this.
think you opened that door when you asked him about the shooting and who the shooter was. And the co-defendant.
When did the two of you decide to rob Lenny Nixon?
We never decided to rob him.
So if Green said you decided to rob him before he was shot, he would be lying?
I mean.
Yes or no? Yes or no, Mr. Jones?
Yes.
Okay. You knew the police were looking for you after Mr. Nixon had been shot, but nevertheless, you didn't turn yourself in, correct?
I didn't know. So after the fact, the next day.
When Lenny Nixon was murdered as part of this robbery scheme with you and Green, you were already under or on bail for UUMV, 2 cases of UUMV, and also a burglary of habitation, correct?
No, sir, never bailed out.
You were charged with those offenses, correct?
Yes, sir.
You also previously arrested for assault on a public servant, correct?
Yes, sir.
Criminal trespass.
Yes, sir.
Another UUMV.
Yes, sir.
Evading arrest. Another evading arrest with a motor vehicle. That's all included in your criminal history, correct?
Yes, sir.
Who is Venetia Jones to you?
I'm
All right, pass witness.
Thank you. Go ahead, Mr. Wilkerson.
Yes, Your Honor, we've got to circle back over some of those. Just to be clear, Mr. Trevor, not Trevor, okay. Nixon was the gentleman who was shot, correct?
Yes, sir.
And you were staying at Nixon's house when Trevor Green came there. Is that accurate?
Yes, sir.
And in fact, and Trevor Green initially told officers that you had discharged the weapon that had killed Nixon, correct?
Yes, sir.
However, even he corrected that statement ultimately and admitted that it was he who had the weapon, correct?
Yes, sir.
And on that evening, he took your phone, correct?
Yes, sir.
and he provided you the firearm that had belonged to Nixon, correct?
Yes, sir.
Now, you were asked about an agreement to rob Nixon of a firearm, and whether or not an agreement was ever reached. At what point, or at any point, and if so, how did you learn of Mr. Green's intent of removing or taking a firearm that had been in Nixon's possession?
It was about that morning, well, I'm gonna say around that night, 1, 2 o'clock.
What do you, and you say around that night, 1, 2 o'clock, what is it exactly that you were told at that time?
Nixon keep pointing the gun in our face. Let's just take it.
And how did you respond?
Leave me out of it. I don't want no parts.
And so, just very briefly, you yourself, Trevor Green and Nixon, had the three of you grown up together?
Yes, sir. We all went to the same school at one point in time.
Now, Trevor Green had just been released from prison, is that correct?
Yes, sir.
And is it the case that Trevor Green was actually coming into town to spend time with yourself and with Nixon? And Trevor Green, when he came into town, he was with his girlfriend, is that accurate? Okay.
Okay, we're not gonna try the whole case. I gave you some leeway. I gave him some leeway. I'm not gonna listen. I understand there's obviously some differences in opinion as to what happened and who's culpable. So that's all gonna be for a jury or for you guys to work out.
For just a couple more in a totally different direction, Your Honor?
Totally different direction.
All right. Now, you said you were getting your medications on the 21st. What medications are you speaking of?
I'm supposed to be taking trazodone, hydroxyzine, presides, and they're supposed to be giving me another type of med for me hearing and seeing things.
So while you have been incarcerated at Jefferson County Correctional Facility, the psychiatric or psychological staff provided by contract have made a determination that you actually have audio or visual hallucinations?
Yes, sir.
Okay, Your Honor, as a result of that, we will need to request.
Just file the appropriate motion.
Yes, Your Honor. I'll pass it over.
I have no further questions, Judge.
All right. And you said you had another witness. Can you proffer what that witness would be testifying to for me?
Your Honor, that would just be his mother, Venetia Jones, and to the little bit of support that she would be able and really the inability to raise funds.
Thank you. Okay, thank you. And I'm glad she's here. Thank you. Where is she? Thank you for being here, ma'am. Okay, anything else?
Just a really brief argument.
Go ahead, sir.
Yeah, I filed it, I put that argument, I made clear in the state's reply to the defense counsel's motion to reduce the bond, so I'm not gonna belabor it. I just hit the high points, Judge. If the court is so inclined, the state constitution, the Texas Constitution allows you to hold this defendant without bond because he committed a felony while on bail for a felony, Judge. I've cited the case law, I've attached it to my reply.
I don't see that reply on this case.
It would have been filed on August the 6th of this year.
I see a couple of things. I see an order. Oh, never mind. It's right here.
Yeah.
Sorry.
I cite Article 1, Section 11 of the Texas
Got it.
Constitution that states that if a defendant is on a felony, on bail for a felony and commits a subsequent felony, the court is well within its discretion to hold the defendant without bond if it so chooses to. And I've proffered to the court that I've spoken with the juvenile probation, with the juvenile department division of our office, and they have begun the process to certify this defendant as an adult, and that burden of habitation is on its way, should be making its way to your court soon, Judge. We've got the criminal history that I think speaks for itself. Your Honor, we'd ask that this court deny the defense counsel's motion to reduce the defendant's bond. In fact, if the court is so inclined, we ask that you hold him with no bond.
Thank you, Mr. Coleman. Mr. Wilkerson, argument?
Your Honor, I think that if you look at all of the incidents that were mentioned by Mr. Coleman, that are all juvenile incidents that have occurred with Mr. Jones, that it is quite clear in conjunction with some of the things that have also been mentioned, and also it fits into some of the write-ups that have been received as well, that Mr. Jones apparently does suffer some mental illness issues, and perhaps maybe we should hold this in abeyance until we can have that properly addressed in order to give the court some additional comfort that some of these behavioral issues might be more appropriately addressed.
Here's what I'm inclined to do at this time. I'm not going to hold the motion. We can always, if circumstances change, file a motion, and I will allow another hearing if there's a change of circumstances. Today, based on the nature of the offense, based on the amount of and nature of the incident reports from jail, based on the amount of and nature of the allegations of criminal history as a juvenile. Mr. Jones is 17, about to be 18, right?
Yes, ma'am.
So based on that, all of that, I am going to deny the motion to reduce the bond at this time. Obviously, it sounds like the jail's doing what they can to get Mr. Jones help. If you want to file a motion with regard to any other competency of whatever you want to file with regard to that, get that filed, and I'll take a look at it as soon as it comes through. All right, you go back with the bailiff. And listen, Mr. Jones, whatever issues you're having, none of that, in my opinion, coincides with how you're behaving, right? So you need to make an adjustment of what you're doing in jail. And if you don't, then Mr. Wilkerson's not going to have any argument whatsoever for me to reduce your bond later or anything like that. So I've probably talked to just about everybody in that dorm, I think, in the last couple of weeks about this behavior. Y'all can all continue to act like you're acting, and y'all can all sit there and wait for your cases and then go to prison or whatever happens. Or somebody can step up and say, I'm not going to act like that. I'm going to get up when I'm supposed to. I'm going to follow the rules. I'm not going to fight. I'm not going to call names. I'm not going to, all those things. It's not that hard. Just follow the rules. You may not like them. Follow them. And if you can't, then stay in there and keep doing it. Does that make sense?
Yes, ma'am.
All right, go back with the bailiff.
Say something off the record.
Get it. Don't worry about that. Okay, let's go to now Deshaun Robertson. Oh, this little, just one little one.
And it's, I mean, it's inappropriate.
But they're not like the rest, at least.
Yes.
All right.
And go after somebody with 20.
I know. All right, are you Deshaun Robertson? And this is cause number 25 DCCR 0914. Ms. Robertson is charged with aggravated assault with a deadly weapon. Mr. Wilkerson has filed a motion asking that I reduce Ms. Robertson's bond, currently set at $300,000. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. And in this case, just so the court's aware, there are several family members present who likewise could testify as to family support within the community, length of time in the community and community activities. What I would note, Your Honor, and what I would apprise the court is that even as of now, having received HIPAA releases from Ms. Robertson, we are in the process of receiving records from Spindletop and Fannin, Your Honor. We believe that condition can be fashioned, even if the court wanted to go so far in this case as home arrest. Your Honor, the truth is that because of some of Ms. Robertson's issues, she has had problems sustaining employment at times. I believe, if I'm not mistaken her, that she actually qualified for SSDI, but of course now that is stopped because she has been incarcerated, and she does have 2 children. One, I believe, is about to graduate.
I have one that's just graduated. He's going to the service, and I have 2 that are in school, in high school.
And okay, so that was my misunderstanding then about the one that she was hoping to see graduate and obviously go off to the military academy. Your Honor, she does have, of course, the assistance of Miss Wynn, who is her mother, who is here, and also Miss Stewart, who is her aunt, is here, and then some of her children's here. Children are here, and even one of their significant others. Judge, this particular case, there are obviously some underlying issues. I think it just makes it a lot easier for us to be able to prepare this case and to undertake the evaluations and potential treatment necessary with regard to the matter. I can understand, of course, the court's reluctance to lower the bond given the severity of the incident. But I would hope that even perhaps Mr. Nichols might be able to throw some considerations out there that might include things like house arrest or GPS only that might give the court some additional comfort in terms of safety to the community.
So let me get some where would you live if you made bond, Ms. Robertson?
I have a house at 55 Davis Drive with my kids.
5555 what?
Davis, THAMES Drive.
Who lives at that house?
Me and my kids.
Which kids specifically?
I have
That's okay.
the 18.
Okay. If it were a situation, Your Honor, where the court would prefer, of course, that, she live with her mother, I believe that's a situation that could be worked out as well. She's willing to, I believe, take on that responsibility.
What about Spindletop? Is there a plan in place for you seeing it going to Spindletop before this incident?
Yes, ma'am. I need to get back on my meds, to get back on my medicines.
So had you stopped going like you were supposed to?
Yes, ma'am. I had medicine to last, and then my caseworker ended up leaving, but I don't drive that far because I'm scared to get on the highways and stuff, so I don't drive. I only know the north end of Beaumont.
So it's our understanding that there had been a lapse in treatment, Your Honor. I won't know more until, of course, I'm able to access those medical records, which I just secured releases for. So.
Mr. Nichols.
Judge, my concern is the severity of this case. She hit a man, ran him over in the car, left him pinned there when she got out and fled.
What is his status?
He was in ICU. This case has only been indicted for 2 weeks, so I do not know his current health condition. I think he's been released from the hospital. I know he was able to give a statement to the police, and I will be in contact with him to see really where we're headed.
Okay. For the record, I am reviewing the probable cause affidavit. There is only one incident at the jail, so that's not something that's of great concern. But actually it is of concern. Do you know why it's of concern? It's because it has to do with your medication.
It's blood pressure medicine that I was taking off of. I have a new prescription and they keep trying to make me take it. I've been on that med since I was 19 years old.
So you thought the appropriate way to handle that was by writing F off on the medical stuff?
No, ma'am, it wasn't appropriate, and I did apologize, and I haven't had any incident with medical since then, and I did give them my med doctor information so they can get the correct medicine into the jailhouse instead of having me on the wrong medication. Because I was told to stop that.
You get a whole lot more being nice than you do acting like that, don't you? All right, so what I'm gonna do is grant the motion to reduce the bond. Going to reduce the bond to $100,000. A condition of that bond is that you are not allowed to drive any vehicle ever for any reason while this case is pending. Do you understand? Whatever that means as far as where you live, if you need to live with mom because you're not allowed to drive, then that's what you need to do. I'm not real worried about that. But I think if you're not driving, I also am going to order as a condition of that bond, if you make it, that you immediately make an appointment with Spindletop, that you follow through with any assessment, recommendations, medications. If you're not doing that, and I want proof of that, so you have to get proof. I want to know when your appointments are. I want to know what the outcome is. You have to get all of that information to Mr. Wilkerson so he can get it to me. If I find out that you've missed an appointment, that you're not taking medication or whatever it is, then that bond's going right back up and you're going to be in custody where I know everybody's safe. Does that make sense? Mr.
No
Nichols?
contact, staff premises.
Obviously, no contact whatsoever in any way with
Lyle Sanders.
You're not to go anywhere near 3215 Gulf Street at Tulane, wherever this happened. I don't know who lives by there or why you were there. Doesn't matter. You can't go around there. Do you understand? And this goes, don't send messages through anybody else. Nobody needs to be contacting him or his family or anything like that. Let all that go through your lawyers and they'll handle that. But don't send messages. It's not beneficial for her if y'all send messages or anything like that to him, okay? If you're caught doing that and I find out that anybody's tried to contact him on your behalf or you contact him in any way, bond goes up. Obviously, we have another big issue. Does that make sense? Anything else?
I think that should suffice, Your Honor.
All right, you can go back with the bailiff.
Thank you.
Thank you, Judge. I believe that's the last.
Thank you.
Be excused.
Yes, sir. Thank you, Mr. Wilkerson.
Thank you, Your Honor.
Let's see. I see one. I'm about to print it out. I just got, just this is all I got. Yes, ma'am. Thank you. You good over there? Okay. I don't know if you need this or not. Okay. What devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Okay. Good morning. Are you? Thank you. Are you Gabriel
Yes, ma'am.
Finley? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Let me do that.
He says, spindle top there here.
Okay. Thank you. Okay. And it is the class A of just regular assault.
We did terroristic threat.
Terroristic threat.
Okay, I'm just gonna write that on that front page. And and that is a lesser.
I believe so, Judge. It was a aggravated
Threatening.
assault by threatening with a knife, and so this is just a threat.
Okay. So lesser included terrorist. All right, Mr. Finley, in cause number 25, DCCR 0766, the state has elected to proceed on the lesser included offense of a Class A misdemeanor terroristic threat, and that's from June 11th of 2025. And how do you plead to that charge?
I was,
Are you guilty or not guilty of the
Guilty.
lesser offense of,
Guilty.
all right. Are you pleading guilty to terroristic threat freely and voluntarily?
yes, ma'am.
And I have here on the computer some documents that have your signature on them. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you understand those documents?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be giving up any right to appeal, so you can't change your mind later? Do you understand?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Finley is not competent?
No, Your Honor.
All right, Mr. Finley, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the Class A misdemeanor of terroristic threat.
Yes, ma'am.
Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that for any time, on that sentence for any time that you've been in custody, that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Class A terroristic threat.
No. Well, it was at a group home. So this is.
In household.
Household member.
Okay, because there's one in the
No, I guess you're in the household.
Yeah, I would think. Okay, so let's see, Jamie's story, that's a MTRP sentencing. All right, ma'am, you're Jamie Story, and this is cause number 23, DCCR 1546. Ms. Story was placed on probation February 25th of this year for the offense of theft of property with previous convictions, and that was enhanced to a third-degree felony. The sentence was a 10-year term in prison that was probated for 10 years. Motion to revoke was filed. We were here before, And the story pled true to all of the counts, 1 through 7. I've received the updated report. Have all of you had an opportunity to review that?
Yes, Your Honor. I have your,
And are there any additions or corrections?
not from the defense.
Just my only thing that I would add, just for the court's recollection, and obviously I, of course, would not hold the court to this. We had some difficulty originally in getting her on probation. She volunteered a couple times, but kind of based on her criminal history, made a stretch to make the offer. The court was
Don't
inclined
talk over
to
her.
go along with it based on some circumstances regarding her homelessness, et cetera. I do appreciate that she took responsibility for a motion. However, I have a note on my original plea papers that the state would be asking for primarily the max on the motion to revoke. But again, I know Ms. Holmes has an argument with some hard times that she's fallen on, and I'm not ignorant of that. I just want to let you know my position, what it was originally.
I appreciate that, Ms. Holmes.
Yes, Your Honor. I believe originally that was my concern with Ms. Story essentially having probation was her lack of resources. In which she continued when she was placed on probation in February of this year. That came to fruition. She originally was at her brother's home. That didn't work out, and then she went to go to Liberty with a friend, and there was pretty much lack of resources, lack of transportation, and she made the decision to then not contact because she got scared. And here we are. Your Honor, my main argument is that she has not been on probation long to get started. She never has gotten started. Now that she's been in custody, they visited with her at the jail to let her know what steps and what resources that they can provide. So she knows that she does have help. If she does fall on these hard times, that is what probation is for. We are asking if she could get that opportunity to get started so that she can get the resources and the help. She states that she's been in contact with her mother, and her mother would be where she would reside if she's reinstated back on probation to get things back on track. I do see in the recommendations that probation stated if she is granted reinstatement to complete the cognitive track of the intermediate sanctions facility, in which I've gone over that with Ms. Story, and she is willing to do that to have an opportunity to get back on track with probation. Your Honor, we do understand she does have extensive criminal history, and this is not her first rodeo. However, we are asking, due to the severity of how long she can be sentenced to prison, that she at least have one more opportunity to start probation and get back on track and get the resources that she needs.
I don't have anything additional, Judge. I defer to what the court deems appropriate.
I mean, what's appropriate is for you to go to prison for 10 years, probably, with your history and the fact that you got this chance in the first place, right? I mean, probation has all the resources to help you, but they can't go find you and force you to take advantage of those resources. That's up to you. You've been on probation, you've been revoked on every probation you've been on. So the fact that we gave you your probation now and that I'm even considering leaving you on it is making me question my sanity, honestly. Do you have anything to say?
I'm just sorry for disrespecting y'all.
I mean, when you never show up, it's pretty much like you're just flipping us off, you know,
I understand.
for giving you an opportunity. And it's hard not to take it a little personal.
And I really am sorry, and I'm sorry for disrespecting y'all, and I will do it right this time,
What will you do different?
every day.
Like what?
I'm gonna get me a job, I'm gonna go to work, I'm gonna go to probation, I'm gonna pay my fees, I'm gonna do everything that I'm asked to do.
Why didn't you do it before?
I didn't have it right.
Well, but you could always call, right? You know, if you don't have a ride again, what happens?
I mean, we're gonna call. I just had a granddaughter born, so.
Today's courtroom session takes several serious turns, but one thing keeps coming back again and again. Probation comes with rules, and when those rules are broken, the consequences can be severe. The hearing begins with Juan Sanchez, who is facing a motion to revoke his probation. The judge explains that Sanchez had originally been placed on probation in 2019 after receiving an 8-year prison sentence that was probated for 10 years. But now, the court is dealing with multiple alleged violations. Sanchez is accused of committing another DWI offense, failing to provide verification of an ignition interlock device, and violating the condition that he remains sober. And when the judge asks the critical question, true or not true, Sanchez admits it. All 3 counts are true. The judge confirms that Sanchez entered those pleas freely and voluntarily, and finds sufficient evidence to revoke his probation. But then comes an important decision. The judge does not revoke his probation immediately. Instead, the case is reset so the probation department can prepare an updated report and provide the court with more information before sentencing. That gives Sanchez another opportunity to present anything he believes the judge should know. But the next case becomes even more complicated. Courtney Joseph is already on deferred probation for assault on a peace officer. Now, the court is dealing with allegations that include DWI with a child passenger, resisting arrest, leaving the county without permission, violating curfew,